Well, thank you everybody for spending some time with us today. We're going to talk a little bit again about record releases. This sort of anticipates that you're doing this on your own, although a lot of this is the same kind of information you're going to have to know and comply with in order to successfully deliver your record to your record company. And along those lines, if you have a record deal, you want to look at your deal and look at what's called Big D delivery. Big D delivery is important because that triggers payments usually. And it also triggers your satisfaction of your delivery obligations, which is something that then triggers things like guaranteed release dates and other items that might be in the contract. So big D delivery is an important thing, and it's defined. It's a defined term. We're not going to get into that today. We will eventually get into that, but not today. And we'll take a couple of sample terms. But there's a long list, as a general rule, in the record deal of things that you have to deliver in order to have fulfilled big D delivery. And that's in addition to the actual recordings themselves. You may be thinking that, well, if I finish my recordings and I just drop them off, then I'm good. I should get my delivery payment. And when I say delivery payment, that's usually a good chunk of your advance. Sometimes it's more than half of your advance, depending on what was negotiated. And, they want to make sure you've done everything, that you've paid everything. There are no outstanding invoices. There's no outstanding producer payments that have to be made. There's no shenanigans going on, to coin a phrase. And so, that is why there's a big long list of things on Big D delivery, most of which we're going to cover today and we covered in the last meeting. So today we're going to talk about artwork, credits, and legal lines. And then on another video, we'll talk about metadata, which is some of this, but not all of this. So artwork can come in various flavors, right? Most commonly, it's graphic design and photographs. Now, those photographs may be from a variety of places. I had one record that I'll always remember, which was one of the David Bearwald records that was devoted to the Kennedy assassination, and he delivered with his record a file of materials that he wanted to go out, literally a file, um, and that had to be gone through. So photographs are usually something that the band has created, something that the web developer may have created, something that may have been commercially um, hired in this, like for example, with the Janet Jackson Greatest Hits record, we had a one photograph that was taken by Herb Ritz and another that was taken by Patrick DeMarchelier. And if you don't know those names, these are two of the top fashion photographers in the world. And you don't just kind of walk into the studio with those guys, right? They they have their own thoughts about how they should be employed, and who should own the copyright, for example, to the photograph. So one of the things you want to do when you're preparing or commissioning photographs for your record is you want to make sure you own them. Right? Now, photographers have their own ideas about who should own the copyright to their photographs. Most of the time, though, you'll be able to either own them outright or tie them up so much that you may as well own them, right? You want to be sure that you have the right in perpetuity to use those photographs, particularly anything in the album cover, which would be album minis in the digital world, but anything that is closely associated with the artist, any visual image that's closely associated with the artist, and more particularly that's closely associated with your album. If you're doing a big tour, you may want to use that album cover as part of your tour campaign, right? Your tour collateral, your merch, t-shirts, tour booklets, anything, websites, anything that you might use in connection with your tour. So you want to make sure you have that tied down. Absolutely, no questions asked. You want to take a look at the photographs and make sure that there's nothing that's going to jump out and bite you one day. For example, we had a photograph that suddenly appeared on what used to be called a dump bin, that's sort of like a cardboard cutout end cap type affair that we used in connection with one of the albums that was of a live performance. Well, there was a photographer who had gone around taking pictures of the audience at that live performance. And one of the pictures he took was of this young couple, right, who were, shall we say, embracing. And it turned out that that young couple, that young couple's parents didn't know they were at the show, and you see where that goes, right? So, thankfully that photographer was on his toes and had gotten releases, had gone to the trouble of actually visiting with the parents. So it turned out that that was a specious claim, but not everybody is going to have that kind of thing that buttoned up. That was a very buttoned up situation. That's not normally what happens. Normally what happens is it's just some picture, right? So, take a hard look at everything that you're putting out there. And if there's anything that looks a little potentially offensive to somebody, not necessarily offensive in a, ontological sense, but that is, potentially a trouble point, then at least know what you're getting into and make sure that you actually want to use that picture and not something less confrontational. Illustrations. Normally, if it's an illustration, I would include art, paintings, visual art in that. And so you know who you are if you're someone who is creating that kind of work. Very often the band may actually create that themselves or someone in the band. So you want to make sure that's tied down. Even if they're in the band, it doesn't hurt, to have either a provision in your band partnership agreement or something that is a side letter of some kind that where the band member acknowledges that they've granted the rights, just like they were a third party illustrator, right? This could include, fonts, maybe if there's like a unique font, try to get that tied down. Graphic designer, same kind of thing. You want to work for hire agreement with a graphic designer. Often, if you're at a label, if you're signed to a label, the label's artwork department is going to do all this. So you usually don't have to worry about it. But if it's something you're commissioning yourself, just make sure that you've got the graphic designer tied up. And in fact, the easy way to do this is to say, who have I hired to do work on my album, right? And whoever those people are, make sure you've got rights to everything that they've given you, right? Because just because you've got photographers, illustrators, and graphic designers tied down doesn't mean there's not somebody else that you have to worry about, right? So do it maybe the other way around, to just say whoever I've hired, whatever their job function is, I want to make sure I own all the rights. Credits. So most of the time, you're going to want to credit or be able to credit everyone who has rendered services in the recordings, and that would be from what used to be called the T-boy, the second engineer, the prime engineer, the mixers, remixers, producers, co-producers, producers assistants, musicians, sidemen, band members, string sections, arrangers, If you had one, you know, maybe even the copyists, I mean, you should get all the credits. Then you can decide who you want to credit and more particularly who you have an obligation to credit. Because most of the time, the only people that you're going to have an obligation to credit are going to be the producer and any step out performers outside of the band. Obviously, if it's a band, then you know, you'll obviously credit the band. But there are situations where you have these unusual bands where they don't want to be named, or they're anonymous, or they make up a name, Cyclops, or something like that. And so you deal with that. But 99% of the time, you're going to be dealing with actual people who are actually going to get credited. There may be some other credits that you need to give in that situation, like so and so performs on Martin guitars or Rickenbacker guitars or whatever it might be, if they have an endorsement deal, right? If any of your band members have endorsement deals for musical instruments, um, you'll want to credit the recording studio as a general rule. You'll want to see if they have any obligations to credit any outboard gear or something, right? Anything odd, just make sure at least what their expectation is, because ultimately you and your label will have the final say on who gets credited in the artwork. For the songs, let's talk a minute about cover songs. So with cover songs, there's a couple of things. The number one faux pas, to be kind, that I see with cover songs is where people think that just because you recorded a cover, meaning that you recorded, let's say, yesterday, by the Beatles, that you somehow get some songwriting credit as a result of that. You don't. You don't. You might if it was public domain, right? And you could get an arranger credit. And there are standard rules at the performing rights societies about how much credit they're going to give you for public domain works. Sometimes with mechanical royalties, I've seen artists, in particular, in the case of ancient instrument type recordings, where it's all public domain works, they will take all the mechanical royalty, right, and claim a publishing interest in that song. Um, you know, who's going to tell them no, right? I mean, it's probably not strictly speaking kosher, but at the same time, it's a round world and people have to live together. And, this is probably not an argument that you really want to have, particularly not as a label, right? Um, on the other hand, what you definitely don't want to do is say, I recorded a cover of Yesterday, therefore I own the sound recording, and those songwriters, Lennon and McCartney. Well, now it's Lennon, McCartney, and Jones. Right? No, that's not how it works. Although I will tell you, there are instances where some of these DIY publisher administrators have just let that go. They've just let that go, and then it gets into the metadata system at MLC or PRO or something like that, and CMOs internationally, and then all of a sudden, something which should be absolutely crystal clear is no longer crystal clear. And there's no good reason for it. And then you have to go and undo it. And what that usually means is that whoever is collecting your money and supposed to be paying it out, like the MLC or a PRO, will say, there's a dispute, right? There's no dispute. There's no legitimate dispute. You didn't write yesterday, okay? That's not what happens. So just keep that in mind. I don't want to harp on it, but it's something that I do see, and it's a problem, and it's not going to get you anywhere. When you deliver, particularly to a record company, when you deliver your credits, right? for the songs, they're going to expect you to deliver the splits, meaning how much of the song is owned by who, and they're going to expect you to deliver publishers for each of those splits. So what that means is, if it's songwriter A who signed to Universal and songwriter B who signed to Warner Chappell and songwriter C who signed to BMG, then they're going to expect a nice crisp piece of paper that says A owns a third of the song, or they each own a third of the song, or one guy is 50% and the other split the other 50%, whatever it is, they're going to expect that to be written out, and they're going to expect the publisher names to be attached to the writers, and they're going to probably expect the PRO for each of the writers to be attached. That may not be necessary as part of the label metadata, strictly speaking, because the label isn't doing performances, isn't paying performances, but it's a good thing for them to know, because somebody who they deliver the metadata to eventually will be doing performances, and it just speeds things along. So I would think about that. And when I say publisher, what I'm really saying in the case of metadata that's delivered to a label or to a DSP is, who do they pay, right? Who ultimately gets the payment? And that's not necessarily the same person who is the publisher on the song. But usually it is, but it's not necessarily. And then sometimes, very often, songwriters will have a co-publishing deal. So it'll be like, Aardvark Music administered by Warner Chappell, right? So you pay Warner Chappell, and then Warner Chappell pays Aardvark Music, right? But you need to tell people that, because otherwise they won't know, and it can create a whole accounting nightmare. Because ultimately, when you deliver this information, there are a number of different people that are going to use that information, number of whom will be in charge of making payments. So they're going to want to know who they make the payment to. In the world of the MLC, very often it's just all goes to the MLC, and then the MLC breaks it down. But it's nice to be able to tell them as much as you can. So with legal lines, if you're not familiar with the term, are the little letters in a circle that you see out there in various places. So let's talk about that. So a P in a circle means P is for phonorecord. And if that word's not in your vocabulary, let us get it into your vocabulary. Phonorecord is an important term to know. It's defined in the Copyright Act. It's basically an audio-only sound recording, or a recording reproducing sound alone, as it's sometimes defined. And that should match the Sound Exchange sound recording copyright owner in terms of how you register this with Sound Exchange. Then there's the C in the circle. And in this context, that typically will mean the musical composition owner, right? So that's the publisher most of the time. So that's, if you see that C in a circle, that's for the song, right? And that's also what you would give to a PRO, or that you would give to the MLC. And then there's something which is called P and C, or usually P ampersand C. And that has a specific term of art in the music business, and that is conveying who owns the sound recording and who owns the copyright in the artwork, right? Not the songs, but the artwork. So P and C means sound recording and artwork copyright, because you can't claim copyright in the artwork. There are some rules about that, but you can. And then you'll see the form that you'll see it in usually is P ampersand C, a year, and then the name of the sound recording copyright owner. And then sometimes, in addition to that, you will see the name and address of the distributor, and that's because of something called the true name and origin statutes that require goods put into commerce to have the name of somebody who they can identify as the manufacturer, so they know who's responsible for it, right? So that pretty much covers all the items we're going to talk about today. Take a look at the checklist that's in the website at the Artist Rights Institute, and we'll see you next time. Thank you.